Order today is September 18th, 2024, and the time is 9:31. Please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, please be seated. Okay, we have 5 items on the agenda today. I'd like to recognize our zoning staff to introduce the first case.
Thank you, Mr. Chair. For the record, Joe Saraceno from the Planning Section, introducing CPA 2022-00010 and CPA 2022-00011, Daniels Town Square CPA. I have the affidavit for publication if you would like that. These are privately initiated map and text amendments to Map 1A, Map 1C, and to Table 1B. The amendment to Map 1A is to redesignate approximately 61.25 acres from general interchange in wetlands to intensive development in wetlands. The amendment to Table 1B will reallocate acreage within the county to keep internal consistency with the LEA plan. And the amendment to Map 1C is to add the northern portion of the subject property into the mixed-use overlay. You'll see what I mean by northern portion in just a second. These amendments allow the development of a mixed-use community under the mixed-use overlay standards. The existing future land use map is on the left and the proposed future land use map is on the right. This property is at the southwest corner of I-75 and Daniels Parkway. Adequate public facilities are available to the property consistent with Objective 2.2. The amendments promote a variety of neighborhood types unique to the area, consistent with Goal 5. With the future extension of Three Oaks Parkway through the site, the focal point of the property kind of moves from being towards the interstate to being towards the local traffic on Three Oaks Parkway, making it no longer a prime area to serve the traveling public on I-75. And these amendments to Table 1B accommodate residential development within the industrial development future land use category within the within the Daniels Parkway Planning District. To be added into the mixed-use overlay, the property needs to be consistent with Policy 11.2.1. It is within the extended pedestrian shed of a Lee-Tran fixed route corridor. Pedestrian and automobile connections can be made to the adjacent existing commercial uses, future undeveloped uses, as well as internal connections with commercial and residential on the subject property. There's adequate buffering between the subject property and the adjacent uses due to limiting that mixed-use overlay to that top portion here. So as you can see, down towards the single-family neighborhood, there's no mixed-use overlay added over there, only north of where Three Oaks will be. And public facilities capacity is available to the subject property. In conclusion, some changes in the surrounding area support the proposed future land use map amendment. The proposed development supports diverse housing options within the county. This location is consistent with Policy 11.2.1. Public services are available to serve the subject property, and staff and the LPA both recommend that the board transmit the amendments as shown in Attachment 1.
Does the board have any questions for staff at this time?
No questions. I have a comment. So, thank you to staff. This has obviously been over a 22-year process to get here today for this. Over the years, the county made Three Oaks Extension a priority 20 years ago, and this is basically the result of that. The road coming out there with the 8 laning of Daniels Parkway, the interchange I-75. So thank you for staff for bringing this home. So it's been 22 years in the making.
Okay. Any further comments or any questions for the staff? Do we have an applicant presentation at this time?
Yes, thank you, Mr. Chairman. Good morning. For your record, Richard Aiken. I'm an attorney with Henderson Franklin here in Fort Myers, and I'm here this morning representing the applicant on CPA 2022-00010 and 11. And we do have a presentation here this morning, and I'll run through this for you. I do have with me my team. Chris Moore is with Waypoint Residential. He's the contract purchaser and the developer on the site. The property is currently owned by Dr. Franz and Dr. Eaton. Alexis Crespo is the planner with RVI. She's here. Ted Treesh is our transportation consultant. He's also here. Jackie LaRoque is the professional engineer with Atwell, and Brown Collins is our project ecologist. And if you have any questions for any of them after I go through this, please let me know. I'll be happy to get them up here. So you can see the location of the site that Mr. Saraceno pointed out. You can see that it's at the corner of Daniels Parkway and I-75. You can also see here that the property is bisected by the Three Oaks Parkway extension. It's about 1 mile from the property to the entrance of the RSWX airport. And right now, current access to the property is along the Daniels 9300 frontage road, which is up here on Daniels Parkway. With the completion of the Three Oaks Parkway extension, the access will then be onto the Three Oaks Parkway extension instead of up here on this 9300 access road. The amendment request, as Mr. Saraceno said, does 3 things. First, it amends LEAP Plan Map 1A, which is the future land use map, to move the property from general interchange to intensive development at 61 acres in size. The second portion of the request is to add 53 acres into the mixed-use overlay. As Mr. Saraceno said, the portion of the property that we're asking to add to the mixed-use overlay is the property to the north of the Three Oaks alignment right here. So this would go into the mixed-use overlay, while the property that's down here adjacent to Old Hickory would not. And the reason for that is that the mixed-use overlay allows some additional height, and so we didn't want to put the property to the south in the mixed-use overlay in order to keep that additional height from being next to Old Hickory and prevent any potential issues that might arise as a result of that. The final portion of the request is to amend Table 1B to reallocate the acreage in order to keep it consistent with the LEAP plan. I do want to talk just a little bit about the Three Oaks Parkway extension. I'm sure you're all very well aware of that and you know the status of it. It's currently under construction. Phase 1, which is from the airport canal up here to the western property line of this property right here, is Phase 1 of the Three Oaks extension. That is underway right now. The property owner here in this case is actually coordinated with the county and with the road contractor in order to allow staging on its property to keep construction traffic off of Fiddlesticks Boulevard and Daniels Parkway and allow staging on its property to complete the construction. If you've been out there, I'm sure you've seen that that's going on. The completion of Phase 1 is expected by summer of 2025, and the beginning of Phase 2 is expected in spring of 2025 or potentially earlier. All of the requisite right-of-way has been conveyed by the property owner in this case. Side-by-side comparison of the current future land use map and the proposed future land use map. So on the left, you can see its general interchange, and on the right, you can see the intensive development with the mixed-use overlay. And as I mentioned a minute ago, you can see that only the northern property we're asking for to be placed in the mixed-use overlay. The southern property, southern portion to the south of the extension will not be placed in the mixed-use overlay. So we talked a little bit about the mixed-use overlay and the change that we're asking for here. The general interchange and intensive development future land use classifications actually both have the same base density of 14 dwelling units per acre. The intensive development allows use of Greater Pine Island transferable development units to achieve up to 30 dwelling units per acre, whereas general interchange is a little bit lower. However, we have a companion rezoning in this case, which is scheduled to go to the hearing examiner soon. And the companion MPD caps the zoning at 20 dwelling units per acre. So at the end of the day, the bottom line is the reason for this change, this requested future land use map change, is not to increase the density. It's simply because by placing it in the intensive development future land use, we're allowed to then put a portion of the property in the mixed use overlay, which allows a few things. It allows some greater flexibility with regard to development, and it also allows some additional height. So this really has nothing to do with density. It has to do with the mixed use overlay and trying to give us a little bit more flexibility in that regard. I know that we probably have some members of the public here, and I'm sure that they're going to raise concerns about traffic, and I understand that being in the Daniels Parkway corridor. We do have anticipation that the Three Oaks extension will relieve some of those concerns. However, I think this slide is very important. I want to point this out. So there's an existing approved PD on the property with almost, I think it's 390,000 square feet of commercial uses that is allowed. That is correct. And so if you compare on Table 5, the top table here, you'll see that the trip generations from the existing approved zoning with the existing future land use on the property. And on the bottom, you see Table 6, which is the trip generation pursuant to the TIS for what we're asking for as part of this plan amendment and ultimately the PD. So the request that we're asking for will actually result in a 32.5% reduction in overall trips, daily two-way trips, right? So this result this request will result in less traffic, less trips coming from this project compared to what is currently existing and approved on the property. And Ted's here if you'd like to ask him more questions about that, but I did think that was an important point for you to hear. Also, I'll tell you that we have coordinated with Old Hickory, who is the development adjacent to the property to the south. We've talked to them through a number of things, the height, location of lakes, things like that. Tried to coordinate with them, and we believe that we've done so, and I believe that they are here and can talk about those efforts to some degree. We've also coordinated with them regarding some of the stormwater management, and we can talk about that further if you'd like, but the stormwater management, we have increased the size of the berms over what would be required in the ERP for the 25-year storm event. They are higher than what is the minimum required there. Mr. Saraceno did discuss the available public infrastructure, so I won't go back through that too much, but there is public infrastructure in place to support this request, including utilities. There's a Lee-Tran bus stop, there's a fire station that's 1.2 miles away, and other services and facilities. As mentioned by Mr. Saraceno, the LPA did recommend transmittal by a vote of 4-0, and staff also recommends transmittal. I'm happy to answer any questions that you may have or get any of the consultants up here to answer any questions that you may have. We would request that you transmit the plan amendment to the state, and I would also request time for rebuttal should there be any public input.
Okay. Does the board at this time have any questions for the applicant? Okay, seeing none, I will open up for public comment. Who would like to speak on this item? If you raise your hand, I'll call you up, and you get 3 minutes. When the light turns yellow, you got 1 minute. Come on up. Please state your name when you come up.
I also have a card name as well.
Yeah, some of the cards don't have any markings on what they're going to talk about, so that's why I'm just going to go with this direction. So,
Very good, thank
are you James?
Yes.
Yes, sir.
My name is James Mason. I am the general manager at Old Hickory Golf and Country Club, as well as a member of the ad hoc committee formed in October 2022 to monitor the development known as the Daniels Town Square. Our committee represents the interest of the club and its 1,000+ members living immediately south of the proposed Daniel Town Square development. We have met with Lee County Development Planning Section and Zoning Section to better understand the county's objectives and review process, and have reviewed all the insufficiency letters provided to the developer. We have also met with the numerous conferences with the initial developer as well as the current developer, Waypoint Residential. We believe the Daniels Town Square plan and it's evolved in a positive direction from the original filings in 2022. We would like to thank the Lee County Commission, Community Development for their time and assistance, and Waypoint for their cooperation to help us understand Waypoint's objectives in developing approach and listening to our objectives and concerns. We understand the nature of the reasons for the proposed comprehensive plan amendment. And in the mixed-use overlay, our group supports this plan amendment and the overlay verbiage because Waypoint has made significant progress in addressing our concerns, to include submitting for the site alignments provided, raising the stormwater mitigation standard from the 25-year to 100-year, continue to study the potential of keeping all vertical development north of the parkway, and continue to study future traffic and circulation issues. We believe this is appropriate for the Commission to transmit the changes and to the state. We thank you for this opportunity to address the attention of this matter.
Thank you.
Thank you.
Would anyone else like to speak on this item at this time? Okay, seeing none, I will close public comment. The applicant obviously doesn't need to address concerns here, so I'll come back for the board for discussion.
Chairman, I move to transmit.
I'll second it, Jeremy. We have a motion to transmit from Commissioner Pendergrass, a second from Commissioner Hammond. Any further discussion?
It's always amazing what good communication does to solve problems.
It was.
So congratulations
It was nice
to everybody.
see. So,
Thank you.
yes, absolutely. Any other comments?
Oh, just briefly again, similar along the same lines as Commissioner Sandelli, I appreciate the folks getting together and working through the evolution of this. This is, as Commissioner Pendergrass mentioned, it was a long time coming. So I'm excited to see Three Oaks Parkway get finished too. I know that's something that we've had #1 on our list for a long time. So thanks.
And I just want to thank all the communities, the Legends, Old Hickory, and Fiddlesticks all been working over this last 20 years. Because the original project 25 years ago, it literally brought Three Oaks Parkway down Fiddlesticks Road itself and came through Fiddlesticks. So through the 20-something years of everybody working together, this is going to be the final product. I think it's going to be a great product once it's all done.
Okay, again, we have a motion to approve from Commissioner Pendergrass, a second from Commissioner Hammond. Any objections? No objections. Item moves unanimous. Please introduce the second item, please.
Commissioners, Dirk Danley from Lee County Community Development. The next case before you today is DCI 2023-31. The request is to amend the existing Gulf Coast Town Center mixed-use plan development to relocate an existing Costco gas facility. It's depicted here in yellow on your screen to an out parcel along Ben Hill Griffin. The request seeks up to 30 fueling positions at the new location. The hearing examiner did recommend approval with conditions, and staff and the applicant are here with any questions you may have.
All right. Does the board have any questions for staff at this time? Okay. Would the applicant like to make a presentation?
Hi, Brad Wester, driver McAfee, Hawthorne, and Debanow, 1 Independent Drive, Suite 1200, Jacksonville, Florida. Here to represent Costco on the matter. I do have a presentation prepared, but I will go with what staff has up, and I'm here to answer any questions. My civil engineer and Costco rep is here as well.
Okay. Does the board have any questions? Commissioner Pendergrass.
If, based upon approval today, when are you looking to start breaking ground?
It's a great question. Probably after the first of the year sometime. We're running permits concurrent with these approvals at risk, obviously, but we need to close on the property after the zoning approvals and the permits, but it would be first quarter probably of next year.
Okay, thank you. If there's a need for it in that area, obviously you see the numbers, obviously Costco's recognized the numbers, and so thank you for responding to that.
Yes, and we have a HEX approval, and we've added some conditions per that HEX approval to this item before you now.
Okay.
Thank you.
Anything further? All right. There are 2 participants of record, so I will call your name. Please come up. Again, when the light turns yellow, you have 1 minute, so please try to finish up in that 1 minute. First will be Keith Morrow. Keith's not here? All right. Neil Montgomery? Nope. Okay, does the applicant, well, there's no concerns here, so any further discussion from the board?
Move the item.
Okay.
I'll second it, Chairman.
We have a motion to approve from Commissioner Wayne, second from Commissioner Hammond. Any further discussion from the board? Seeing none, any objections? No objections, item moves unanimously. Please introduce item number 3.
Good morning, Commissioners. My name is Mary Sue Groth. I'm with the zoning section of Lee County. The next item is the Alico Lakes Villages CPD amendment for Tract I. The request is to amend zoning on 2.7 acres of the Alico Lakes Villages commercial plan development to allow 90,000 square feet of mini warehouse and public warehouse uses. The property is located on the northeast corner of I-75 and Alico Road, is located in the industrial, commercial interchange, and trade port future land use categories and zone commercial plan development. County staff and the hearing examiner have recommended approval with conditions and deviations, and I am available if the board has any further questions.
Okay. Does the board have any questions for staff at this time? Okay. Does the applicant wish to make a presentation?
Good morning, Fred Dravlik, RBI Planning. Just here for questions. I do have a backup presentation in case there was a specific question.
Okay. Anything from staff? Or the board, excuse me. No? All right. I do have 3 participants of record. James Field. James here.
James Field and Greg Stewart are here. I'm here with Luke Kane. I was presented on behalf of a district landowner, but no comment.
Luke Kane.
That's Luke.
Oh, that's you. I'm sorry. I didn't hear the name when you said it out. Okay. So no. All right. Greg Stewart. No. Okay. So we have no concerns. All right. So would the board like to have any discussion or a motion?
Move the item.
Second.
Item moved for approval from Commissioner Pendergrass, second from Commissioner Hammond. Any further discussion? Good. Seeing none, any objections? Item number 3 moves unanimous. Please introduce, I'd like to recognize staff to introduce item number 4, please.
The next item on the agenda is for DCI 2023-00033 for the Heights Career Technical School at the Crosslands CPD. The request is to amend the Crosslands Commercial Plan Development approved by Resolution Z8681 as amended to increase commercial retail intensity from 23,000 square feet to 66,500 square feet, and increase the approved building height from 35 feet to 50 feet. The property is located at 10940 Gladiolus Drive, east of Pine Ridge Road and west of Edisto Way in the Urban Community Future Land Use category, and it is zoned CPD. County staff and the hearing examiner have also recommended approval with conditions and deviations on this project. And again, I'm available if the board has any further questions.
Any questions from the board at this time? Okay. All right, seeing none, does the applicant wish to make a presentation?
Only if you have questions.
Any questions for the applicant? Okay, seeing none. There are 5 participants of record, so I will call your names. John DeMaster? John here. Jim Dwyer? No. Chuck Ketelman?
I'm here, but I'm happy not to speak.
Okay. Also, Kevin Shimp? Charlotte Wheatcraft? No? Okay. So at this time, would the board like further discussion?
Chairman, I'd gladly move approval of the hearing examiner recommendation and just add the comment that this is an exciting new opportunity here to have a new technical school. I know this organization has done great things for the community already, and I'm looking forward to seeing more trained, skilled workers coming out of this area.
Yeah.
I'll second that, and like Mr. Hammond said, that's a great area there within the Gladiolus community there, so thank you.
I was out there last week and been there a number of times. It's a great piece of solving a lot of different issues in our community, so certainly support it.
Great job. Thank you.
All right. You did second that, right, Commissioner? Yes. Okay. All right. I have a recommendation for approval from Commissioner Hammond, a second from Commissioner Pendergrass. Any further discussion? Any objections? Item moves unanimous. I'd like to recognize the staff to introduce the 5th item, please.
For the record, Adam Mendez, Senior Planner with the Community Development Zoning Section. The last case before you, Commissioners, is in reference to DCI 2021-00038. Project name is Spring Lake RPD2. Subject property is approximately 5.6 acres. It's located on the south side of Cypress Lake Drive near its intersection with South Cleveland Avenue. The subject property is located in the central urban and intensive development future land use categories and is also currently zoned tourist commercial CT. The request is to rezone the property from CT to residential plan development RPD to facilitate development of up to 56 dwelling units, multifamily and townhome. The hearing examiner's recommendation for the case is approval with conditions, and there are 5 participants of record. Staff is available if there's any questions.
Okay. Any questions for staff at this time?
I have a question. If you could answer this, the applicant, the existing homes that's there, are they still being occupied there? Are they still living in that? I know that community. I know people who used to live there, but are there still people living in the part with those part being rezoned?
Yes, there are 8 existing units on site here. I believe they're all occupied. They are retained as part of this plan development. So of the 56 units that we're discussing here, only 48 are new.
Okay, so those would stay existing as they are?
Yes.
Would the new architectural design be the same? Would it be compatible with that, or would it be a totally different type of structures?
There would be no additional architectural requirements for the scope of those units on the property. Okay. New units would be subject to Chapter 10 standards.
So would they look the same? We don't know if they would look the same.
We don't know if the architecture is going to look the same at this point.
Okay, thank you.
You're welcome.
Any further questions? Okay. Would the applicant like to make a presentation?
Good morning. My name is Amjad Siti. I'm actually the engineer for the applicant. The applicant is sitting here with me. I don't have further comments. The reasons we're doing this is to correct the nonconformities on some of those lots because they're not developable if it remains as it is. The other things I want to note that we're not increasing densities. We're actually remaining within the same densities that the future land use allows for this. And the third point that I want to bring out is that we did receive some concerns from the property owners adjacent, which is a different separate property and a separate HOA. So we provided an attorney letter to the effect that they reviewed this and it does not infringe on their rights. It does not propose any changes to the deeds or the agreements. So the zoning request in front of you is for this subject property. And the owners on this subject property have all signed up on it. 75% is the requirements. And we did provide an attorney review to address any changes, and they determined that there's no changes to the deeds, covenants, or any rights of any other owners. With that, I available for questions. I also have the applicant with me if he wants to speak or anything. Okay, so we're here to answer questions.
Any questions or anything for the applicant at this time?
I see there's five participants. What were the concerns of the residents?
The concerns
are those residents that live there? I see one is not a resident that lives there.
They're not residents. None of the applicants that are speaking, I think, today are residents of this community.
Okay, thank you.
All right, so there are 5 participants of record. I will call you to the podium again when the yellow light is. You have 1 minute left. The first will be Adiko Ambrose. Adiko. Please correct me if I pronounce your name wrong.
Good morning.
Morning.
My name is Ildiko Ambrose, and I'm living in 3150 Shorewood.
If you can.
Oh.
Yeah, please. Yeah,
Okay.
there you go.
I'm living in a high-rise in Spring Lake condo in C205. And I just have a few things to say. I know I have a short time, but sorry for my English. So the consent and authorization does not have signature of 75% of the 38 unit owners of Spring Lake Community Association. I opposed rezoning and I agree with everything stated by the public at the last meeting and the new evidence about signatures on the consent authorization and HOA reference letter. The proposal looks like it's building on the community space, which is next to our swimming pool, and it's, my acknowledge is not his property. The signatures on the consent authorization do not match property owners' names. Mr. Timmis has never paid community association fees on the undeveloped land, unlike the 38 unit owners have. Most of the residents are elderly, retired, and live on fixed income with limited access to zoning documents. I would like to submit copies of the new evidence, consent, and authorization of HO reference letter. Okay.
Thank you. Up next will be Marcia Ellis.
Is this for the record? Here? It's okay. Is that for the record? All right. She wanted to submit that for the record. Hang on just one second. Thank you. I'm also submitting for the record the letter that please don't start my time yet if you don't mind, because I need to put a couple of things on the record. I want to submit the letter that I brought to the zoning hearing on July 24th, 2024. I had also requested that this letter be forwarded as part of the packet so that you could review it today prior to this hearing, that it was in that packet for your review, and so I have copies for each of you. I also pulled the letter from the county attorneys from the original 2021 that has the concerns from the county about that the lots are non-conforming and that they couldn't be developed. So I pulled that to make sure everybody got a copy. There's plenty of copies. Give me just a second. Do you mind to start my time now? Please?
Restart it?
I'm just trying to get the copies first, if you don't mind.
Okay, we'll
Thanks.
restart it. Go
I
ahead.
do appreciate that courtesy. Thank you
Yeah.
so much.
Yeah.
This is Marcia Ellis for the record. I live at 17850 DeVore Lane, Fort Myers, 33913, in a different zip code. But I do have procedural concerns about this case. I came to this hearing because that morning I was unable to access the zoning cases at all, and this isn't the first time I've had issues with access. So I penned a letter and I came to the hearing. I shared this letter as part of this case, stating that I was unable to get the information I needed in order to be able to inform any public comment, etc. The access continued when this case was brought forward in the packet for you guys. It had the wrong case number on the cover, so I had called and spoken to Jamie about that. She then contacted Maria and corrected it. I was continuing to have access issues up until this morning. I was able to only access 25 of 27 files, and I was only able to access the 2021 file this morning, of which I pulled the county attorney's letter at that time. There's an issue with the transcript. There wasn't a court reporter, and so the transcript was created in-house, creating an additional burden for the residents of Spring Lake if there is challenge. The letter is, I put on record the non-conforming letter, and that calls attention to the fact that the signatures that were presented as consent and authority were for non-conforming parcels that no one lived in, no one paid maintenance fees on, no one paid anything on these parcels that could not be developed, but yet they were counted as signatures. The 75% on the application excluded the residents of the other parts of the condominium. This common area is shared by 3 different subgroups underneath a larger community window dating back to 1979 when this development began. What is being proposed is taking part of their common area to intensify and get development entitlements that they are not allowed to have. This whole thing is really an abuse of power on the part of someone who has ambitions within the development. It creates a lot of conflict, and it's putting folks on a fixed income at in a real disadvantage. It fails to meet the essential requirements of law in terms of what was presented in the application. The opine, which was a requirement of the original application, was just submitted yesterday. So I suggest that this be remanded back to be corrected. These folks have been advised to seek a civil court case, and that is by staff, in order to enforce the bylaws which they're attempting to put on record. So we need to think about protecting the public, providing legal services to the elder folks so that they don't fall prey to these predatory practices.
Thank you. Patricia Godwin.
Okay, my name is Patricia Godwin. I live in B4. I oppose the rezoning. I agree with everything that was stated in the first meeting. Today we're going to submit the new evidence, consent and authorization, and HOA letter. The consent and authorization did not have 75% of all the residents. It was only 75% of that little block. The proposal looks like it's going to take up what is our community space. The consent authorization doesn't, signatures don't look like they belong to the owners. Mr. Timmis never paid community association fees on the undeveloped land, unlike the 38 other owners do. Most of us are retired and living on a fixed income, and it's hard for us to access these notes and things that are online. And I'm submitting copies of the new evidence, consent and authorization, and HOA letter. Thank you.
Thank you. Up next is Leila Russell.
I am Leila Russell, and I live in B2 of 3130 Shorewood Lane. I oppose the rezoning, and I agree with everything stated by the public at the last meeting, which was I think in July. And we have new evidence about the signature on the consent and authorization, as much as HOA reference letter. The consent and authorization does not have 75% of the signatures of our 38 units. The proposal looks like it is going to be built on community space. Signatures on the consent authorization do not match property owners' names. Mr. Timmis has never paid community association fees on that undeveloped land, unlike all the residents, 38 residents. Furthermore, most of the residents are elderly, retired, and live on the fixed income and do not know how to navigate the court papers. I would like to submit copies of the new evidence, consent, and authorization, HOA reference letter, and the Spring Lake Condominium and Spring Lake Community Association bylaws for the case file. Thank you.
Thank you. Up next is Damon Sayer.
Good morning.
Morning.
Everybody says Sayer, it's actually Damon Sire.
Sire.
Just
Well,
like,
there we
just
go.
like
We got it
Meyer.
corrected. Thank you for correcting me.
Okay, I am a current owner at Spring Lake Condominium Association, which is also Spring Lake Community Association. And I oppose the rezoning and agree with everything that was stated in the previous last meeting. And new evidence about the signatures and the consent authorization and the HOA reference letter. A lot of this is repetition of what was said earlier, but I think it needs to be said because there's a very definite need here. The consent authorization does not have the proper signatures of 75% of the 38 owners of Spring Lake Community Association. The proposal looks like it's building on the community space. I'll explain that in a moment. The signatures on the consent authorization do not match the property owners' names. And Mr. Timmis has never paid community association fees on the undeveloped land like the 38 other Spring Lake Community Association owners have. Most of the residents are elderly, retired, and live on a fixed income with limited access to the zoning documents. I would like to submit the copies of new evidence, consent and authorization, and HOA reference letter in the case file. Now, in order for this to, that was presented previously, there were a number of different things that were incorrect, done improperly. The signatures weren't obtained properly. There were, in some cases, no signatures at all. And this was a large deceit, not only for the board, but also for Spring Lake Community Association. It's totally wrong. And what is being proposed is that there would be a condo complex built on what is our amenity as Spring Lake Community, which is right to the west of the pool. That's Spring Lake property. Mr. Tennis cannot build any condominiums on property that is not his. It is owned strictly by Spring Lake Community Association, period. So those buildings in that area have to be eradicated from the process. They cannot be added. Anybody have any questions?
Well, it's not a question answer for us with you. So, in other words, no, we don't have any questions for you.
I'm sorry?
I said it's not a question and answer for us.
Oh,
back
okay,
and forth.
I understand.
Yeah, that's okay. So
All right, it all has to be reviewed. It's all in the documentation, and you'll find that there were a number of different deceiving things that took place in order to come up with.
Thank you, sir. Thank you for your comments.
My pleasure. Thank you.
Does the applicant want to address any of the concerns presented here? Yes, please come on up.
So thank you for all the input. It's well received, but I want you to focus that this project is for this property, for this HOA, which is Spring Lakes 2, which is different entirely from the HOA that all the people that spoke are part of. So it's a separate property, separate HOA. We did have an attorney review it, and they determined, and the letter was provided yesterday to the county attorney, that the applicant is entitled to move ahead with this rezoning without any detriments to the existing covenants and deed agreements that go back years ago. The 75% requirement is for this property, is for this HOA, not for another HOA, not for another adjacent property, not for another resident that doesn't live in this property limits. One more comment, one more note, is when this applicant goes to develop the property, they have to adhere with all of the development, section 34 of the county code for development. So as far as architectural, heights, number of parking, traffic, it all has to be reviewed again by staff to be conformant with the physical limitations of the property. Those are the points that I want to emphasize. The owner that I heard his name many times, Gabriel Timmis, he's sitting right here, and he's available to ask any questions, but all the 75% were obtained legally, I mean, as far as I know, and they are presented to the county attorney. So this has nothing to do with this particular application. That's all I wanted to add, and Gabriel, if you want to add anything?
All right, at this time, does the board have any questions or comments at this time?
Mr. Chairman,
Commissioner Hammond.
can I just ask our county attorney, I'd love to hear from our attorney to give us some advice on, first of all, could you just give me like a basic, I don't really understand a lot of the comments that have been made. So just help me understand.
Okay.
You're recognized.
Thank you very much. The county regulations have, depending upon the type of applicant and the property owner, certain restrictions or regulations with regards to who must sign off on the authorization to proceed with the application. The members of the public have concerns over what we call, let's just call it the 75% rule. As the applicant's representative just indicated, there are two separate properties. The ownership of each property is different, and they acquired the percent requirement for their own property, the Spring Lakes 2, if I've got those numbers correct. The members of the public are also concerned with some of their common elements of the amenities that are on from Spring Lake 1's property that are on Spring Lakes 2's property, and they are concerned with the proposed development and the impacts of this development on those amenities. So there's two separate issues with regards to that. There are code requirements for the applicant submitting the necessary authorizations has been satisfied. The code was amended back in 2023 for particular types of applications like this one. And one of the new code requirements requires an opinion from their council indicating that the proposed application is not inconsistent with the bylaws and the declarations for that particular condominium. That was provided yesterday. We have that information in file, and that does meet the code requirements for filing the application. The members of the public and their concerns with the impacts on their amenities, that is a civil issue that is outside the scope of this proceeding. If there are any issues with regards to the authorization to impact those amenities through the declaration, through the bylaws, that is something that this board does not enforce. The county does not enforce those. That is something for them to proceed in civil litigation if they deem that to be inconsistent with their amenities and their Spring Lake 1 regulations. So there's two separate matters going on at the same time, but from the board standpoint, the requirements to file the application, the authorizations needed for that have been provided, have been reviewed, and it is sufficient to proceed at least with the application.
Okay, okay, any further questions or comments?
So Michael, what you're saying is basically our jurisdiction is what's before us today, the zoning case, which is approval from the HECS with conditions. The other issues as far as the property adjacent to their HOAs, that's all civil outside the jurisdiction of the Board of County Commissioners, correct?
That is correct. We do not enforce declarations and bylaws.
Right. I get that. I'm just saying people that may not know the process here think we have that jurisdiction. We do not have the jurisdiction to a civil case between the jurisdictions of the different HOAs or even a CDD, for example. So we do not have that jurisdictional authority, correct?
Correct.
Thank you.
You know what, one last question too. Let me just ask this question too. So I know a lot of people will say, well, it's okay, you're the government, you can do whatever you want. What would be the consequences for us if we tried to rule on something that was outside of our jurisdiction that's more of a civil matter?
Well, there's a term that Ms. Ellis likes to throw around recently about essential elements of the law. You would be in violation of them if you were to try to impose that, because the county does not have any regulations allowing you to, in essence, review and impose the restrictions in a declaration. You would actually not be following the requirements of the law, of your law. And that would not be illegal.
That would not be, okay. Well,
Okay. Anything further? No. Would anyone like to make a motion? It's always the
I have
time.
a question for the HECS.
Absolutely. Mr. Pendergrass.
Did Donna Marie or Amanda hear this case? Without looking, who heard this case? Who heard this case? Was it you or Amanda?
It was me.
Okay. Did these issues arise during your hearing examen or comments? I heard they kept saying we were referring to the prior meeting, the comments were before the prior meeting, which we're not, we don't have those before. So was some of these concerns brought up then? And did you weren't allowed, basically weren't allowed, based upon your jurisdiction, you're not allowed to even touch those issues either.
Exactly. Unless the county attorney concluded that there was a legal infirmity in the application,
Okay.
the remarks that were voiced to me at the hearing by the community pointed to a civil matter, a civil dispute that is outside the scope of my authority. So I focused my review on the application consistency with the Lee Plan and Land Development Code, and I was not able to consider those other issues.
Right. So you basically had a big decision based upon the land use that was before you, like we're voting on today. And
My analysis focused on what I believe the county's scope is in connection with this property, and there may be legitimate private disputes, and that needs to be handled with another forum
administratively through your office, everything is properly done, notice, and just compliance.
I didn't have this letter that got submitted post my hearing, but it sounds like that it was a procedural issue that the county attorney feels as though as long as we have it, you know, the deal's been read, so.
Okay. Based upon our county attorney hearing examiner's recommendations, I make a motion to approve based upon that within our jurisdiction to do that.
Second.
Okay, I have a motion to approve from Commissioner Pendergrass, a second from Commissioner Hammond. Do we have any further discussion? Any objections? Seeing no objections, item moves forward. Seeing no other business before us, we are adjourned.